I'm not the chairman of this subcommittee, but I think through common agreement with the members that are here, we will not detain this distinguished group of panelists any longer. This is a very important continuation of discussions that the Constitution Subcommittee has been engaged in, and it essentially evolves around cell phone technologies and how they've changed, but how the law hasn't changed. And we're trying to see if we can come together to sort out some of the differences in views that are coming out of the court. And of course, I think very few of us can anticipate the technologies that are evolving so rapidly. I would like to invite the former chairman of the Judiciary Committee, Jim Sensenbrenner, the ranking member of this committee, to begin our discussions.
Well, thank you very much, Mr. Chairman. And as you know, I have to give a statement on the floor a little bit after 10:30, so I appreciate your giving Republicans the first word this time. And, you know, I know this is somewhat unprecedented, and again, I appreciate your indulgence. Today's hearing is the second in a series of hearings to examine the need to update the Electronic Communications Privacy Act of 1986, or ECPA for short. This hearing addresses cell phone site information and other location-based technologies. A collection of civil liberty organizations and telecom companies have proposed a series of principles for ECPA reform, including that law enforcement access to cell phone and cell site location information should require a warrant based on probable cause for both prospective and retrospective location data. Second only to the advent of personal computing is the technical revolution with mobile communication devices. Industry trade groups estimate that at the end of 2009, there were over 285 million wireless subscriber connections and over 2 trillion annualized minutes of cell phone use. Almost 23% of U.S. households today are wireless only. As I've said before, at the intersection of all the new technological developments and capabilities are the privacy rights of the public, the economic interest in expanding commerce, the public policy of encouraging the development of even better technologies, and the legitimate investigative needs of law enforcement professionals. As cell phones have created greater efficiency for consumers, they also have created greater efficiency for criminals. Fortunately, they also provide new ways to law enforcement to investigate crimes. There seems to be a confusion, or at least a difference of opinion, as to exactly what location information is acquired by which technology. Some technologies may only identify the general area in which a target is located, and others can be more precise. It's important for this committee and Congress to clarify the true nature of these technologies before we embark on reforms to ECPA. There also seems to be confusion in the courts, or a difference of opinion on what portions of ECPA apply to these technologies and under what standards self-location information should be inquired. Considering that ECPA was enacted in 1986, well before the proliferation of cell phones and other technologies, I think it's fair to say that the statute does not speak specifically to these issues. At a fundamental level, traditional PIN, register, and trap and trace data are the telephone numbers dialed from or the telephone numbers dialed to for a particular telephone. In Smith versus Maryland, 1979, the Supreme Court ruled that an individual has no reasonable expectation of privacy in the information gathered by these PIN and trap devices. As the Internet and cell phone technology advanced, Congress expanded the PIN trap statutes to include certain non-content information from emails and cell phone calls. In enacting the Communications Assistant to Law Enforcement Act of 1994, or CALEA, Congress specifically instructed that a person's location information cannot be acquired solely pursuant to a PIN register. The Stored Communications Act, an act as a part of ECPA, governs law enforcement requests for various types of stored information. Under an intermediate standard of specific and articulable facts, courts have widely held that the government can use the Stored Communications Act, to acquire certain subscriber records, including retrospective cell data, location data. However, the Third Circuit Court of Appeals is currently considering the application of this statute to retrospective cell site location information. The United States has appealed the denial of an order for historical information, even though the government complied with the provisions of the statute and based their application on specific and articulable facts showing that the information is relevant to an ongoing criminal investigation. From commingling of the pen and trace statutes and the Stored Communications Act has evolved a hybrid order for requests of certain prospective cell site information. Some courts have accepted this theory and some have not, opting instead to require the government to obtain a warrant under Rule 41 of the Federal Rules of Criminal Procedure. While there may very well be a need to clear up the confusion in the area of obtaining prospective cell site location information, it does not necessarily follow that the appropriate remedy to any ambiguity would be a Rule 41 search warrant based upon probable cause. I thank the witnesses today, and I look forward to their testimony. Let me say this is a very complicated area. It's not one that I think reeks of partisan divisions. I think we all know that a 24-year-old original law and a 16-year-old second law is way out of date compared to where the technology is at. And in order to clear this up for everybody, whether it's the courts, the law enforcements, the cell phone providers, and everybody else, Congress needs to be very professional in doing what needs to be done to bring this up to date, and that haste may make waste. Thank you.
Thanks, Jim Sensenbrenner, for your opening comments. And I now turn to Hank Johnson, himself a former magistrate in the Atlanta court system, and presently the chairman of the Courts and Competition Subcommittee and Judiciary. You're welcome to begin whenever you want, Chairman Johnson.
Thank you. Thank you, Mr. Chairman, for holding a very important hearing. Looks like my mic is not working, so I will just speak loudly. This important hearing will give members the opportunity to examine the Electronic Communications Privacy Act with respect to location-based technologies such as cell phones and smartphones. The Electronic Communications Privacy Act provides the standards for law enforcement access to the electronic and wireless technology we use. Specifically, this hearing will give members the opportunity to hear from witnesses about reform under the Act and issues relating to historical and real-time location data. This hearing is timely as mobile communication devices have evolved from being little more than a convenience for the wealthy to a basic necessity for most Americans. Cell phones have transformed the way we communicate and work with each other on a daily basis. In today's society, it is more common for one to have a cell phone rather than a traditional landline phone. According to a 2009 Wireless Association report, there were approximately 277 million cell phone service subscribers in the United States last year. That is about 90% of the overall population. Whenever these subscribers have their cell phones on, the phones can automatically scan for cell towers and register location information with the network. This has led to substantial privacy concerns as cell site data may be collected without a person's knowledge. Further, some data provides the ability to track all of a person's movements on a relatively precise and continuous basis. When it comes to law enforcement and national security, The value of a person's location at a particular moment in time cannot be overstated. Criminal investigators can use this information to find a child that has been kidnapped or to apprehend a dangerous criminal. While the benefits of technology to aid law enforcement are great, it is important to remember that Americans have privacy rights. The founding fathers recognized that students need privacy for their persons, houses, papers, and effects. While technology has been advancing at the speed of light, that basic principle the framers had in mind when they drafted the Constitution has not changed. Therefore, it is important to have a balance between user privacy expectations and law enforcement needs. I will deviate from my prepared remarks to let you know about a recent experience that I had this week while I was here in Washington. I got a call from my scheduler over here at the Capitol, who told me that she had heard from my dealership that my car had registered, sent back a message that it was time for an oil change. And so I have the OnStar technology in the car, and but I did not know that whatever data recorder is in the car would notify the dealership that the car itself needed some topping off of the oil. And that is sobering to me, to know that someone sitting up at a computer terminal can see where I am, where my car is, or at least where my car is, and what kind of condition it is in. They probably know how fast I drive it. And can that information be shared on a commercial basis without my knowledge? Those are some of the issues that we'll be facing in the future. The ability to monitor communications has grown enormously. As technology continues to expand, Congress should adjust laws accordingly to keep up with modern technology. And by the way, when I get home, the first thing I'm going to do is look at that OnStar contract and see exactly what it provides for and what it does not provide for. It's come to Congress's attention that the standards governing law enforcement access to historical and real-time cell site data regarding location information may be the most confusing area of the Act's application to wireless technology. With more than 500 federal magistrate judges serving in district courts around the country, there is no room for confusion when it comes to the Electronic Communications Privacy Act. If courts are issuing conflicting decisions with different standards regarding law enforcement access to this wireless location data under the Act, Congress should step in and act accordingly. I'm anxious to hear from the witnesses today, as I have a number of questions. Should Congress step in and reform the Electronic Communications Privacy Act? If so, how should the Act be reformed to strike the proper balance between consumer privacy and law enforcement? What should law enforcement officers have to provide cell phone providers in order to obtain access to historical and real-time data? Would it be premature for Congress to legislate if there are unresolved Fourth Amendment issues? I hope our witnesses can shed light on these questions, and I look forward to hearing from the witnesses, and I yield back the balance of my time and would request a working microphone.
Thank you. You might try the one on the other side. Let me just say before I read my opening statement that Mr. Johnson's opening statement raises some interesting possibilities. I didn't know that the car told the dealership when it was thirsty. I'm pretty sure pretty soon it may be telling the insurance company that you're not replacing the brake fluid often enough or whatever, and this raises real questions about about your car communicating with other entities without you even knowing about it, and perhaps influencing your legal liabilities or rights. Today's hearing is the second in which this subcommittee will consider the statutory framework Congress established in the 1986 Electronic Communications Privacy Act, ECPA, in light of the enormous technological advances in electronic communications in the 24 years since ECPA's passage. While the first hearing was a general introduction to several ECPA reform issues that should be examined, this hearing will focus specifically on advances in cellular location-based technologies and related services, and how such technologies, while enriching our lives, can provide more precise and, to many of us, more sensitive information about where we may be located at any given time. So today we continue our examination of whether ECPA still strikes the right balance between the interests and needs of law enforcement and the interests of the American people in privacy. If we conclude from this examination that the balance of interest between law enforcement and personal privacy must be struck more finely, we will take the necessary legislative action. If we embark on that course, we must bear in mind the exigencies and complexities of the security environment in which law enforcement must act. Moreover, if we act, we must do so with the full knowledge that any legislative changes to ECPA must nevertheless sustain the public's confidence in the security of their communications, or it could harm both the robust market for cell phones and the rapid innovation that is fundamental to that market's health. Because ECPA inevitably involves the interaction of all these important and complex considerations, we are taking the time through a series of multiple hearings to educate ourselves carefully and fully before beginning to engage in any legislative action. This subcommittee's exploration of where the appropriate balance may lie with respect to location information must surely include a lesson in location-based technologies and services. After all, when ECPA was passed back in 1986, approximately 8 years before the GPS system was fully activated for public use, the only options one had for locating oneself on the road was still a road atlas or a gas station. Now, as we will see, the GPS is supplemented by an array of different location technologies and the myriad applications they support. We are honored to have certain witnesses here today who are experts in these technologies. They can give us the necessary background to embark upon an understanding of how they work, what types of information and records they can generate and store, and how they can be of assistance to law enforcement in appropriate circumstances. This initial educational effort is, in my view, not only warranted but essential before we undertake any effort at amending or otherwise reforming ECPA. After we hear the terrain described, we will move on to other questions today, namely, how is ECPA currently being applied to these location-based technologies and services by the courts? Without stealing his thunder, we have one very distinguished witness here today who will tell us in the most respectful way, I'm sure, that Congress needs to give better guidance to the courts with respect to the standards governing law enforcement access to certain types of location-based information. He is a magistrate judge working, as we say, in the trenches, who has grappled with how to apply ECPA to law enforcement requests for various types of location-based information. In many respects, at least for the moment, the testimony and discussions today may raise more questions than they answer. Since we are to hear about technologies both existing and those that are foreseeable, that are revolutionary, certainly by 1986 standards, I want to acknowledge that our task will be a challenge. To find the appropriate balance between privacy and law enforcement interests, to protect the public while preserving consumer privacy and confidence, to support rapid technological innovation, yet discern standards for law enforcement access that will not become outdated with each new generation of technology every 3 or 4 years. As I indicated, this journey will at least initially take the form of a dialogue, and this subcommittee needs the assistance and input of all stakeholders, law enforcement, private industry, and civil liberties groups alike, in order to have any hope of getting this right. We look forward to speaking with you formally or informally and seeing you at future hearings. The Chair will now recognize the distinguished Chairman of the full committee for an opening statement.
Thank you, Chairman Nadler. I'm going to put my statement in the record and make just a couple observations. The first is that what our distinguished judicial witness did is extremely important in leading this committee under your guidance to begin this evaluation of the relationship between the incredible outpouring of technology and the fact that our laws sometimes are not keeping up with it. In addition, we have the problem of not being able to anticipate what new technology is coming out in the first place. So it's a sort of built-in problem. Do we try to process the congressional role in a normal way, or do we try to anticipate what's going to happen? But I think the basic thing that Judge Smith has pointed out, and it reinforces the importance of this hearing, is that the courts are in disarray themselves, and understandably so. We've been looking at the 1986 law. Essentially, it was created to govern law enforcement access to electronic and wire communications. It created different standards, some that are very high. What is a super warrant anyway for wiretapping? And some that are very low. What is a subpoena for telephone toll records? And so this law, written before the technology existed, has understandable problems. But it's to the credit of this committee that we have embarked on this discussion. This is the second of a series, and it sure won't be the last. And it's in this spirit that I commend all five of you distinguished witnesses, experts, in coming here to help us unravel this problem today. I thank you for your presence.
And I thank you. Without objection, all members will have 5 legislative days to submit opening statements for inclusion in the record. We will now turn to our panel of witnesses. Our first witness is Matt Blaze, who is an associate professor of Computer and Information Science at the University of Pennsylvania, where he serves as director of the Distributed Computing Laboratory and conducts research on computer security, cryptography, network communications, and surveillance technology. Much of his research focuses on methods to strengthen critical infrastructure against criminals and other unauthorized eavesdroppers, and to help ensure that authorized surveillance systems work as intended in the rapidly changing environments in which they must be reliable. Prior to joining the faculty at Penn, he worked for 12 years on the research staff of AT&T Labs in New Jersey. Professor Blaze earned his PhD in computer science from Princeton, a master's degree from Columbia, and his undergraduate degree from the City University of New York. Our second witness, Michael Amorosa, is Senior Vice President of Public Affairs at True Position, a location-based technology company. Prior to joining True Position, Mr. Amorosa spent 24 years with the New York City Police Department in various managerial capacities, including 3 years as Deputy Commissioner for Technological Development, where he was directly responsible for the design and implementation of the city's E911 system. Mr. Amorosa is also chairman of the E911 Institute, an organization that provides administrative and policy support to the Congressional E911 Caucus. Mr. Amorosa received his J.D. cum laude from the New York Law School, a master's degree in public administration from NYU, and his B.A. from St. Peter's College. Mark Zwillinger, I skipped somebody. I'm sorry. Richard Littlehale is an assistant special agent in charge of the Tennessee Bureau of Investigation Technical Services Unit. In this capacity, he coordinates and supervises the use of advanced and covert technologies in support of law enforcement operations, and he is a federal task force officer with an FBI Joint Cybercrime Task Force. Mr. Littlehale is a graduate of Bowdoin College and received his J.D. from Vanderbilt Law School. Mark Zwillinger is a founding partner of Zwillinger Janetsky LLP, where for 10 years his practice has focused on issues related to the Electronic Communications Privacy Act, the Wiretap and Communications Act, surveillance law, and privacy. Previously, Mr. Zwillinger ran the privacy and security practice groups at Sonnenschein, Nath & Rosenthal, and at Kirkland & Ellis. Prior to that, he served 3 years as a trial attorney in the Computer Crime and Intellectual Property section of the Criminal Division of the Department of Justice. Mrs. Willinger earned his J.D. magna cum laude from Harvard Law School. And finally, Judge Stephen Smith has served for the last 6 years as the United States Magistrate Judge for the Southern District of Texas, Houston Division. Before his appointment to the bench, he practiced law for 25 years in the Houston office of Fulbright and Jaworski, LLP. Judge Smith earned his B.A. cum laude from Vanderbilt University and graduated from the University of Virginia Law School. I think we have 2 witnesses from Vanderbilt at some point. I am pleased to welcome all of you. Your written statements in their entirety will be made part of the record. I would ask that you summarize your testimony, or try to, in 5 minutes or less, which will be liberally construed. To help you stay within that, no, we don't have the time. Do we have the time thing? Yeah. To help you stay within that time limit, there is a timing light at your table. When 1 minute remains, the light will switch from green to yellow and then red when the 5 minutes are up. Without objection, the chair is authorized to call a recess of the hearing at any point, which we will endeavor to do only in case there are votes on the floor. Before we begin, it's customary for the committee to swear in its witnesses. If you'd please all stand and raise your right hands to take the oath. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief? Thank you. Let the record reflect that the witness has answered in the affirmative. You may be seated. We will now hear from our first witness, Professor Blaze, who's recognized.
Thank you, Mr. Chairman, for the opportunity to talk to the committee today about the technology of wireless communications and tracking in wireless communication systems. It's a great honor to be here, and I'm humbled by the task of trying to distill what is in fact not just a very complex legal area, but a very complex and often confusing technological area. Wireless technology, as we all know at the risk of gross understatement, has since 1986 exploded in popularity and undergone numerous generational changes that have completely changed the landscape, not only of how we communicate and interact with each other, but of how the underlying technology works and how we think about it. So what I'd like to discuss first of all is the way cellular telephone networks work and are structured. The cellular telephone, unlike the traditional wireline telephones that we grew up with, uses radio to communicate with the wired telephone network instead of a cable connected to your home or office. This is essentially by itself a revolution in the way we think about a telephone, because it is no longer fixed to a particular location. We carry our phones with us now, rather than thinking about the telephone located in a place that we think about the person we want to call, because we expect them to have their telephone with them. We can move around with these devices, usually anywhere in the country, or almost everywhere in the country. And we expect our telephones to work, and largely they do. I was surprised to discover my telephone worked in the DC Metro on my way here this morning. Cellular providers accomplish this by deploying a network of relatively closely spaced local radio base stations, those ubiquitous cellular telephone towers that we see in neighborhoods and alongside highways, that are each responsible for completing telephone calls made by cell phones in their immediate area. Cell phones, as they move and as they're turned on, discover the base station with the strongest radio signal and perform a registration process, identifying themselves, establishing that the user has valid cell phone service, and identifying the local base station that is best equipped to process the call by virtue of the strength of its radio signal. Now, it's very important that coverage be contiguous. So essentially what cellular providers do is divide their coverage area, essentially the United States for most of the cellular providers that are there today, into a mosaic of local base station service areas that are called, in the terminology of the industry, sectors. So the base station with which a phone communicates covers an area called the local sector that it has radio coverage, good radio coverage for. Now, when you move from sector to sector, or when you place a call, cellular phone companies keep track of that, so they know where incoming calls should be routed, which base station they should send the call to have your phone ring. When you place a call, they know that you already have established that you have a valid account and have paid your bill, and so forth. So cellular...
On a technical point, so when you move around with your phone in your pocket, they know where it is only if you make the phone call, or just because it's there emitting a signal?
No, any time the telephone is on, the phone periodically will check the signal strength of the local base station, send it a message saying, essentially, can you hear me? I'm in this. I'm in your sector. Please register me. And the phones periodically do this. They do this when they're turned on. They do this as they move from place to place. And in order for you to be able to receive incoming calls, it's very important that the phone company, the wireless company, keep track of which sector you're in, because that's how the switching equipment knows which base station to send an incoming call to cause your telephone to ring. So anytime the phone is on, anytime it moves around, whether it's actually making or receiving a call, the wireless provider is tracking the current base station with which a phone is associated. And that's just an essential part of how the network works. Now, how do we track phones? What kinds of location tracking technology is available in this world of kind of everyone carrying around a wireless handset? Well, the most prominent location tracking technology, the one that's most visible to the end user, is called GPS, which makes use of the Global Position System satellites originally put up by the US military, that allow a device with a satellite receiver and a view of the open sky to calculate very precisely its own location.
Excuse me, and your cell phone in your pocket has that capacity to talk to the satellite?
Well, many cell phones do, but not all do. And in fact, although GPS technology is the most prominent location tracking technology for the end user, it's actually not the most important technology for the surveillance and tracking point of view. GPS has high accuracy. It can, the latest generation of equipment can precisely locate something to within about 10 meters of accuracy, less under some circumstances. And it can be done by a device by itself with no other infrastructure than the ability to receive the satellite signals. So we have GPS mapping systems in cars and so on, and the latest generation of telephones often include a separate GPS receiver and some mapping software and other software that can emulate the functions of, for example, a car GPS receiver. So from the user's perspective, we often think of GPS as being the equivalent of location tracking. And we might think that if we don't have a GPS receiver on our telephone, that no one might know where we are. But in fact, that's not true. GPS is actually not used by the cellular telephone network for tracking at all. And law enforcement use of GPS for surreptitious surveillance with cell phones is less important than other kinds of telephone-based tracking when we're talking in the context of wireless communication. Now, the most basic kind of wireless tracking with a cell phone is to simply keep track of which sector the telephone is located in at any given moment. As phones move from place to place, as I mentioned, they register their location with the local base station. The wireless company keeps track of that. It has to, because if it doesn't, it won't know how to get calls to you. And so if we keep track of which sector a phone has registered with, we effectively know where it is within the service area of that sector. Now, a natural question to ask is, well, how accurate does this allow us to locate the phone? How big a radius might the phone be in when it's registered in a particular sector, as phones do continuously when they're on? And the answer is, today is very different from what it was 25 years ago. In the original cell systems, which were analog, not widely used, very expensive, and there weren't that many cellular customers, the incentive for the wireless service provider was to try to get by with as few base stations as possible that would adequately cover the service area in a way that would satisfy their customers. There weren't very many customers of cell phones in the earliest systems, and so really the limiting factor of how far apart base stations could be was the distance that the radio signals would travel. But that meant that a sector might be several miles in diameter, up to 10 or sometimes even 15 miles in diameter in the early cell phone systems, in areas with wide open terrain and relatively few users. So knowing the sector location in early cell phone systems only allowed you to locate, a city or a neighborhood in which a phone was located. But as cell phone systems have become so explosively popular compared with the way we thought about them 25 years ago, there have been other factors that have resulted in the sector size steadily shrinking. There are a limited number of simultaneous users that can be served by a cellular base station. When cellular technology wasn't as popular and was very expensive, this wasn't much of a factor. The radio ability of radio signals to penetrate the area was the limiting factor. But today, the limiting factor in how far apart base stations can be is the number of customers they have to serve. And as this technology has exploded, the number of customers in any given area has gone explosively up, particularly in urban and densely populated areas. At the same time, we as cellular users have more choices, there's more competition, and we've become more demanding of our cellular service providers, and we expect our phones to work in more and more places. We expect the coverage to be more and more reliable. As I mentioned earlier this morning, I discovered my phone was able to receive a call, to my surprise, in the metro subway. Being able to provide service over a continuous area requires, again, that we include sectors that cover dead spots and that are able to provide good signal coverage everywhere we go. Those ubiquitous advertisements, "Can you hear me now?" reflect cellular service providers' competition with one another to provide base stations that cover more and more service area more and more densely. So the effect is that the size of a sector today is far smaller than it was 25 years ago because of the natural evolution of the technology.
Sum up, perhaps, in particular, tell us how big a sector is these days.
Right. So the largest sectors can still be several miles in diameter. In rural areas, sparsely populated areas. But the latest technology has trended toward what are called variously microcells, picocells, and femtocells that are designed not to serve an area of miles in diameter, but rather to serve a very, very specific location, such as a floor of a building or even an individual room in a building, such as a train station waiting room or an office complex or hotel or even a private home. So as we've moved toward these very small sector locations, we can, if a user is in one of these very small sectors, essentially determine their location.
Exactly where he is. Let me ask one question, and we have to ask you to go on to the next witness.
Mm-hmm.
It is physically necessary for the system to operate, for the system to know where your cell phone is in order to route the calls there. And obviously, the smaller the area, the fewer the competing calls, and that's why it gets smaller and smaller, with obvious implications for accuracy of telling us. What is the technological necessity and what is the practice of retaining this information? In other words, they need to know where you are now so they can route the call. Do they need to know where you were an hour ago or a day ago, and do they retain this information, and if so, why?
Well, every service provider, I should say, I'm not speaking for any service provider, and every service provider will have its own practices. But in general, service providers record everything essentially forever. This information is extraordinarily valuable for business, marketing, and technical purposes. It tells them where their network needs to be improved, where dead spots are, and how their customers use their phones.
Thank you very much. I'm sorry we went over here, but we have to get a basic education in the basics here, so we know what we're doing. So at least we think we know what we're doing. Our next witness is Mr. Amoroso.
Good morning, Mr. Chairman, and is this on? And members of the subcommittee. My name is Michael Amoroso, and I am the Senior Vice President of True Position. It is a privilege to appear as part of the subcommittee's examination of the Electronics Communication and Privacy Act. Wireless technology plays an ever-increasing role in the daily communications of Americans, including during emergency situations. Of the 300,000 emergency calls to 911 daily, over half are now from wireless phones. This shift has made the ability to locate wireless calls the core element of our nation's emergency response 911 structure. Expeditious and effective emergency response has been at the center of my professional career. I spent 24 years working in public safety, and it was my honor to manage the largest 911 center in the nation, that of the New York City Police Department. During that tenure, we completed major upgrades of the system and infrastructure that were needed to support the NYPD's mission. Since leaving the PD, my role with True Position has given me the opportunity to work with a range of agencies in tackling ongoing and heightened national effort to bring modern technology to support emergency response, preparedness, and investigations. Long before wireless technology became prominent, policymakers and emergency response officials embraced the critical need to quickly locate individuals facing an emergency. The faster help arrives, the more likely lives are to be saved. This premise underlies the FCC's mandate that the wireless operators provide public safety agencies with location information in an emergency situation. The requirement, as you know, is known as Enhanced 911. It dictates that the location of the wireless 911 calls must be transmitted to the appropriate emergency call center. True Position's very existence has evolved from the wireless location mandate. We are the leading provider of location determination solutions. Currently, 2 technologies address the FCC's location accuracy requirements. They are GPS, which was discussed earlier, and uplink time difference of arrival. Both of these technologies use what we know about radio waves. We are able to measure the distances from a known point, such as a cell phone, to an unknown point, such as satellites and transmitters. Because we know radio waves travel at constant velocity and are able to make calculations to locate the phone from that point. UTDOA differs from GPS in the network-based works in virtually any environment. It is not affected by obstructions such as tall buildings or concrete walls. It is able to locate all mobile phones, including those that are not GPS enabled. Its accuracy is very high and typically falls within 50 meters of that accuracy level. Technology is extremely useful in law enforcement situations as well. Police used UTDOA recently to rescue a woman kidnapped in Hamilton County, Ohio, who was locked in the trunk of a vehicle. GPS was not an option because it could not penetrate the metal trunk. A UTDOA location platform allowed police to constantly monitor the victim's location and apprehend the kidnappers. In addition to serving 911 calls, wireless location technology has evolved in several public and private sector applications, including locating victims suffering from Alzheimer's, autistic children. It can be used to locate contraband cell phones in prison environment as an alternative to prison jamming. Wireless technology has revolutionized communication. Unfortunately, it is also being used by criminals and terrorists. In the 2004 Madrid bombings, terrorists used improvised explosive devices to attack morning commuting trains, killing 191 people and wounding over 1,800. Mobile phones were used to detonate these IEDs. High-accuracy technologies are a crucial element in the preparedness, investigation, and response to these dangers. True Position's UTDOA technology delivers two key important elements in mission-critical location: high accuracy and high reliability. It can provide information relating to the details of criminal conduct and be an important tool in preventing tragedy. It can present an additional dimension to the comprehensive information picture that intelligence and law enforcement officials use on a regular basis. True Position's security solutions capture and analyze wireless data, including current activities, mobile events, and interactions. The technology can help identify and track any mobile device in a real-time mode in any environment with high accuracy and reliability. It can be deployed in such areas as border security, critical infrastructure protection, and law enforcement to aid in forensic intelligence. Location technology has contributed to saving lives and personal property. To allow for the continued use and growth of this life-saving technology, I urge that any government action in this area of wireless technology remain technology neutral. I commend the subcommittee on its efforts to bring the ECPA up to date and appreciate very much the opportunity to appear before you today and welcome any questions, Mr. Chairman.
Thank you. I'll now recognize Mr. Littlehale.
Chairman Nadler, Ranking Member Sensenbrenner, and honorable members of the subcommittee, my name is Richard Littlehale. I'm the Assistant Special Agent in charge of the Technical Services Unit of the Tennessee Bureau of Investigation, and I've spent the better part of 15 years using communications records to protect the people of Tennessee. I'm grateful to the subcommittee for giving me the opportunity to share my perspective on how location information derived from communications technologies can be invaluable in the most critical of law enforcement investigations. I offer testimony here today on my own behalf based on my own experience. As communications technology evolves, so must the laws that govern it, and there is always room for clarification. That said, I believe that the balance struck between privacy and public safety in the existing ECPA framework is in the broad sense a reasonable one, and I would respectfully call your attention to some risks inherent in upsetting the current paradigm. I cannot overstate the value of location evidence to law enforcement. It can help find a kidnapped child, apprehend a dangerous fugitive, or prevent a terrorist from following through on a violent plan. We're not just talking about cell site information either. Imagine a pedophile grooming a potential child victim using a chat application on a smartphone. Law enforcement must be able to quickly generate and serve process on however many service providers are necessary to find that subject before the unspeakable happens. The current legal framework distinguishes between network transactional location records stored and recorded by the service provider in the ordinary course of its business and demand-based location information generated solely based on a law enforcement request. This information is reasonable because this framework is reasonable because it is consistent with other ways location information can be obtained and used by law enforcement, and because it is consistent with the view that information voluntarily turned over to a third party enjoys less privacy than those things we keep from the outside world. A person's location at a particular time can be derived from any number of sources other than mobile devices. A bank will have records of a customer use of a credit card or ATM card in their possession that would show exactly when and where that particular card was used. A transportation authority might have records of when a commuter passed by a particular toll booth based on the information provided by their commuter pass. Those records can currently be obtained with a subpoena in most cases. Should that standard change? Even the law of tracking devices permits installation and monitoring without probable cause under some circumstances. Complexity is hardly foreign to the Constitution. The same piece of property, a person's suitcase, say, may be governed by completely different legal standards when it's laying on a closet shelf, in the trunk of a car, or passing through a border checkpoint. If we suppose that a blanket standard is necessary, we must consider the consequences of rounding up to probable cause in all cases. Location information can be used to good effect in many instances where law enforcement may not have developed probable cause. Further, the time required to generate a search warrant and have it signed may itself hamper law enforcement's efforts to move quickly in an investigation. I fully acknowledge that the above argument could also be used in favor of relaxing the search warrant requirement completely in order to make law enforcement more efficient in all investigations. Of course, such a thing would be foreign to our bedrock legal principles. In this case, however, the present balance of judicial supervision and law enforcement efficiency has existed for some time and should not be abandoned without a demonstrated need. Finally, even a blanket standard is going to have trouble covering everything in this area. Imagine our pedophile with a smartphone again. Say he is using the Wi-Fi in a coffee shop, and that activity generates information that can be localized to that particular shop at a particular time. That is location information, far more accurate than a cell sector. Would it require a search warrant to get that information from the shop's internet service provider? Generating a search warrant for each and every child exploitation lead will slow the processing of those leads. If that is acceptable, then so be it, but it is a downstream effect that must be considered. And what about broader locations? Are we only talking about cell sites? What if I just want to know what market your phone is using, what city you're in? That's location information. We must also remember that legal barriers are not the only ones that keep communications records out of law enforcement hands. In many instances, we are unable to utilize evidence that would be of enormous value in protecting the public because the technologies used to carry and store that information are not accessible to us, no matter what legal process we obtain. Encryption, smartphone countermeasure applications, and a dizzying variety of communication streams are walling off more of the evidence we need at a steadily increasing rate. If the law enforcement community does not successfully bridge this gap with legal reform, training, solutions development, and funding, then our ability to protect the public using this information will degrade at the same breakneck pace. Whenever our society moves forward with the privacy versus public safety debate, we should be mindful that any redefinition of law enforcement's access to the information it needs, whether by altering legal barriers or allowing private corporations to elect new technological barriers, may well come at a price. Admittedly, we cannot let extreme situations rule the law, but neither should we ignore the fact that they exist. What seems like a small change in an abstract setting may seem less so when I'm standing on your doorstep at 4 in the morning and your child is missing and every second counts. Thank you for giving me the opportunity to share one law enforcement perspective on the need for caution as we open dialogue on ECPA reform. I encourage you to seek the input of a wide range of law enforcement experts as you move forward on this critical issue, and I look forward to your questions.
Thank you. Mrs. Willinger is now recognized.
Thank you, Mr. Chairman. I'm very pleased to be here today to discuss ECPA reform generally and location data specifically. I've been working with ECPA for over 13 years. First as a DOJ attorney who used to teach prosecutors and agents how to acquire electronic evidence, and for the last 10 years as a lawyer helping ISPs and wireless providers respond to the government's request for data. As a result, I can tell you 3 things about ECPA. First, it's complicated. Second, it has done a fairly good job over the past 20 years in striking the right balance between law enforcement needs and user privacy. But now it is definitely in need of reform to bring its privacy protections into the modern age of cloud computing, social networking, and mobile networks. One area where ECPA no longer functions well is with regard to location data. This morning I want to focus—
Excuse me, could you just tell me what you tell us what you mean by cloud computing?
The storage of data as opposed to locally on your computer in your possession, but out in the network, on the internet, in the cloud.
Thank you.
With regard to location data, ECPA is not functioning very well anymore. And I'd like to focus on 3 of the issues I put forth in my written statement. 1, the type of location data that raises privacy concerns. Second, the discrepancy between acquiring real-time data and historical data. And third, to answer Mr. Johnson's question, the reason why Congress should not wait for the courts to resolve these issues. First, as to location data generally, of course Mr. Littlehale is right. Law enforcement obtains a wide variety of records that provide insight into a person's past location. For example, a landline call or a credit card receipt can shed light on where a person was at a given moment in time. But when those transactions occur, it's reasonably clear that some record is being made of that event, and only limited information about an individual's movement is disclosed. The type of location data that concerns us here has the opposite characteristics. It may be collected without a person's knowledge, and it allows the tracking of a person's movements on a relatively precise and continuous basis. This type of tracking is much more persistent and much more intrusive than the disclosure that I bought a coffee at Starbucks at 9 o'clock this morning. This is why it's also a mistake to think about ECPA reform solely in the context of relatively imprecise cell site location information, because whatever the limitations are on cell site limitation today, cell tower data will rapidly evolve into the more precise and consistent information that's being supplied by GPS technology. Second, as to getting historical data versus prospective data, the existing statutory framework clearly distinguishes between the two. As to past location data, the application of ECPA is fairly straightforward. Location data, at least for calls, is properly considered a record or other information pertaining to a subscriber or customer, which the government may get under Section 2703D of the Stored Communications Act using the specific and articulable fact standard that's explained in Judge Smith's chart. But the framework for real-time data is not anywhere near as clear. On their face, you would think that the pen register and trap and trace statutes would allow the government to access location data under a relatively low standard that requires a court to issue a pen trap order whenever a government agent certifies that the location information is relevant and material to an ongoing investigation. But when Congress passed CALEA in 1994, it precluded law enforcement from relying solely on pen trap authority. The government's workaround, which you've heard about, has been to combine the authority of a pen trap order with the historical request for data under Section 2703D. But this doesn't work. An order under 2703D can only provide access for historical records, not prospective data. It is not a surveillance statute, and there are no provisions in 2703D that contemplate future surveillance or provide limitations on duration and minimization and monitoring. So it can't be the additional authority that Congress needed in 1994 when it said law enforcement could not rely solely on pen trap. So how can it be that there are different rules for obtaining information about where I was an hour before an order was signed compared to an hour after an order was signed? Those rules are entirely different and clearly to this date unresolved. Some courts have tried to fix this discrepancy by creatively applying the tracking device statute found in 18 U.S.C. 3117 to apply to both types of data. But as I describe in my written testimony, I don't think a tracking device statute can apply to a consumer's own electronic devices. But the fact that courts are trying to do so is strong evidence of the need for Congress to step in and harmonize the before and after rules for the same set of information and to set a properly robust standard for the government to meet before it obtains precise location data. Finally, as to Mr. Johnson's question, I don't think Congress should expect that the problem will be resolved by the courts anytime soon. First, the application of the Fourth Amendment to location data is uncertain. Even if every device that emitted location information was considered a tracking device, the Fourth Amendment alone would not necessarily mandate a prior warrant to collect information from these devices. In fact, in Knotts and Caro, the leading Supreme Court cases, the court suggested that a warrant is only required where the data from a tracking device reveals information about private spaces. Certainly, cell phones may be carried into private spaces. They're not always in private spaces. And second, just last week in the Kwan case, the Supreme Court deliberately shied away from extending Fourth Amendment protections to rapidly evolving technology. So, in conclusion, I don't think Congress should share the court's reluctance to address privacy concerns created by modern technology. Competing claims over privacy rights are being litigated on a daily basis. And as everyone struggles to apply a 1986 law to technology that is becoming more precise in its ability to pinpoint location, the time is ripe for Congress to set out clear and sustainable rules that better balance user expectations and law enforcement needs in light of modern technology. Thank you for the opportunity to testify today.
Thank you, and I'll now recognize Judge Smith.
Thank you, Mr. Chairman, ranking members, members of the subcommittee. I'm honored by your invitation to appear at today's hearing. I am a United States Magistrate Judge, but I am testifying on my own behalf this morning, not on behalf of any group or organization, but it is testimony informed by hands-on experience with ECPA over a number of years. Ordinarily, your committee would probably be better served by hearing from a Supreme Court justice or a Court of Appeals judge steeped in the law, able to give a full exposition of its strengths and flaws based on years of experience and observation. But on this topic, cell phone tracking, that would not be possible. Very few appellate courts have dealt with ECPA in any respect over the years, and as Exhibit B to my written testimony shows, not a single one to date has dealt with the question of legal standards for compulsory government access to cell site location information. Ponder this fact. For nearly a quarter century, magistrate judges have been issuing tens of thousands of these orders under a fiendishly complex statute without any substantial guidance from any higher court. And now I can't think of another area of law in which that could be said. Now, FISA perhaps, Foreign Intelligence Surveillance Act, but then FISA is a special case and was understood to be a departure from routine law enforcement for everyday crime. I believe that is an unhealthy state of affairs for our democracy. First, without a functioning system of appellate review, the process of refinement, clarification of statutory ambiguity and uncertainty cannot take place. And this is especially unfortunate for a statute as complex as ECPA. A more serious concern is that a basic check on judicial as well as prosecutorial power has been removed. Without the discipline of appeal, every magistrate judge essentially becomes a law unto himself or herself, answerable to no one. And law enforcement is able to channel their ex parte applications to a judge known to have the more accommodating view of the law. Now, this does not happen with respect to ordinary search warrants. The cause of this unhealthy state of affairs, in my opinion, is the regime of secrecy that has enveloped ECPA.
Excuse me, why does this not happen with ordinary search warrants?
Well, because ordinary search warrants are issued pursuant to a warrant under the statute, under Rule 41, and under that rule, the party whose house is being searched gets notice, receives a copy of the warrant. Typically,
it's not ex parte.
Not sealed, right. Not well, it is ex parte, but before the search is carried out, the person whose
gets notice.
home is being searched gets notice. Now, the cause of this unhealthy state of affairs, as I said, is the regime of secrecy. Under ECPA, gag orders and permanently sealed cases prevent law-abiding citizens from finding out whether and to what extent their electronic lives have been intruded upon by government. Again, this does not happen when law enforcement searches your home or your office or your car. The difference boils down to notice. Without notice, and this can be pre-acquisition or post-acquisition, but without notice, due process of law becomes a dead letter. So I applaud the committee's efforts to reform ECPA to face the new technological advances of the 21st century. But the problem with 20th century ECPA is not just that it failed to anticipate new technology. Few of us back then could have imagined the cell phone of today and what it can do. The problem is that it is an overly complex statute that was allowed to operate almost entirely in the dark, off the radar screen of the general public, as well as appellate courts. Thus, the balance that it struck, at least in my view, between privacy and law enforcement has been eroded, and few seem to notice, at least until now. Now, your task will be to strike a new balance that will be sustainable for our time and time to come. My prescription for sustainability is twofold: more bright lines and more sunshine. I believe the principles endorsed by the Digital Due Process Coalition go a long way towards the former goal. I think my written remarks suggest some ways to accomplish the latter. All right. In closing, I want to thank this committee for inviting the views of one of the hundreds of magistrate judges who wrestled in the trenches, as you say, with this statute for years. And with that, I'll be glad to answer any of your questions. Thank you.
I thank you. I thank all the witnesses, and we'll start the questioning by recognizing myself for a while. Professor Blaze, with regard to newer technologies that measure time and angle of arrival, you state that according to the policy of the carrier, a customer's location information might be routinely received by that carrier or not, even at times other than when calls are made or received. what factors might or does a carrier consider in electing whether to store such data or not?
Well, the important thing to understand is that, first of all, this technology is not yet fully deployed in every cell site, but carriers are embracing time of arrival and angle of arrival calculations, not just to comply with E911 mandates for providing location during emergency calls, but because it provides them with extremely important information for managing their network. In particular, it tells them where their customers are located to a resolution of typically about 50 meters, and it tells them where they move about.
Why would they want to know within 50 meters where their customers are?
Well, it tells them where new infrastructure is needed, where old infrastructure is redundant, whether the expensive real estate for a tower is paying for itself properly, or whether they can afford to move it to another location, whether microcells are required, and so on. So it is very strongly in the interest of a wireless carrier to collect this data as often as possible and as pervasively as possible, to store it effectively forever, and to analyze that data intensely, just for the operation of its own business.
Thank you. Mr. Amorosa, I was struck by one thing you said. You said, therefore, the distance between 2 points, radio waves propagate at a constant velocity, obviously. Therefore, the distance between 2 points can be determined by measuring the time it takes a radio wave to travel between the 2 points and multiplying by the velocity of the propagation of the radio waves to derive the distance. But that assumes you know what time it left. You know what time you received it. In order to know the distance, which is to say the time of propagation, you have to know the time it left the transmitter. How do you know that?
Based on putting receivers on the cell sites, you take the differences in time that it hits all the different cell sites.
Difference of time, so you triangulate it by...
Exactly, exactly.
You know the distance from here and the distance from here.
Right.
And okay, thank you. Now, also, you state that true position location technology used by GSM carriers can identify mobile phone devices typically within 50 meters. 50 meters is how many feet? Just for us.
It's roughly about 3 feet a meter, so you're talking
So it's
about
150 feet. Is true position able to provide this high degree of accuracy after the fact, or only when requested prospectively by E911 operators and law enforcement?
The way the system works right now, you establish triggers in the system to do locates. You don't locate every call. If you couldn't, the network couldn't handle the location of every call. Right now, the only way you do that is based upon the fact of either being prior written consent or an E911 situation where the call would come in. Prior written.
Wait a minute. I thought from your testimony, Professor Blazes, that it automatically recorded every call because that's how you get all this system information. In other words, it automatically records, not the call.
We're not locating every call. The way the system works today is we're only locating those calls that have certain triggers, and the triggers are the E911 calls that are coming in. And that's the way we're providing location back to the carrier.
But I thought in order to, well, let me ask Professor Blaze, this seems to contradict what you were saying a moment ago about you need to know the location of all the calls to figure out how many cells you need where and so forth.
Do you want to
So the cellular carrier always records the cell sector location for every call and any time the phone.
Sector for every call, the specific location only where
a specific location only when specifically requested. My understanding is that cell carriers do that, as Mr. Amorosa points out, on E911 triggered calls, on phones under surveillance, and also periodically on random phones to figure out what's going on.
Okay,
as the technology becomes cheaper and more widespread, they can do it more and more often.
So in other words, the question I was going to ask Mr. Amorosa next is, can true position technology be used by carriers to gather and potentially retain this high accuracy location information on all subscribers at all times, or is this high accuracy information only collected and retained after an appropriately valid legal request by authorities? You answered the latter, and you also said it would be cost prohibitive to do the former, but Professor Blaze is saying that that cost prohibition will erode, and it is predictable at some time in the future that you may be able to and may, in fact, become standard to get this very sensitive location for all calls?
I don't know if it'll become standard. I think the capabilities will eventually exist, but whether it becomes standard,
The capabilities will exist, it'll get
Another issue.
cheaper, and it may or may not become standard.
right.
And, thank you. So, I mean, we have to worry about that as a possibility. Now, can True Positions UTDOA systems work in virtually any environment?
Yes, I can.
Because the radio waves will penetrate anything?
The way the system will work, you have in-building capabilities that certain other technologies do not have. You have the ability, if you can make a call, and if you look at your phone now, you'll see that you have the ability to make a call inside. We can locate that airway. It's not blocked by the diffraction of concrete walls.
And that's because
steel.
it's a stronger signal than it used to be, or what?
It's because it's using radio waves, and it's not going back to the satellite. It's going to the transceiver where the transmitter is picking up and making that call go through
It's
the
going
system.
to the cellular tower, you mean?
Right, exactly.
And the radio wave that goes to the cellular tower is more powerful or more penetrating than the one that went to the satellite?
Because of the fact that the GPS chip is where you're locating from rather than from the radio wave.
I'm sorry.
The GPS system is located based upon the chip in the phone, which is communicating with the satellite,
Right.
as opposed to the radio wave, which is communicating with the base station receiver. And the radio waves can penetrate through buildings and through concrete walls and steel structures.
Yeah, but the radio wave going to the chip to the satellite also has to penetrate that wall.
And it doesn't. And it doesn't reach the satellite because of the way the satellite systems work. You have to have an open sky capability and the
Okay.
ability to see the satellites. and
Because it's at a
preferably
different
from-
angle, because it's going up as
Right.
opposed to...
Exactly.
Um,
You take, for instance, if you tried to use a GPS capability in the Wall Street area in New York City, even though you just can't get through because of the narrowness of the streets.
Mhm. Thank you. Mrs. Willinger, we've heard much today about revolutionary location-based technologies that give extremely precise information about where an individual or individuals may be at any given time. Can any meaningful legal distinctions be drawn that should inform our review of the ECPA statute and its application to location-based information? To your knowledge, does DOJ draw distinctions with regard to location information derived from different location-based technologies? Is that a sensible way to make a distinction based on what technology is used?
Well, unfortunately, it's been the only one so far. Let me go through three possible ways to draw a distinction. You know, one way to draw a distinction is between historical and prospective data, and for reasons we've talked about, I think that's not a rational distinction. It's the same invasiveness 5 minutes ago versus 5 minutes from now. The second one is where the Fourth Amendment points, which is
Well, wait a minute. Let me just challenge you on that. Where you're located right now might be important for an emergency use. You need a paramedic quickly, or you use E911, etc. Where you were may be important for evidentiary reasons, which is very different from an emergency response. So maybe you should make a rational distinction.
Well, I think emergency is the distinction there, though. I mean, none of these, no ECPA reform would really do much to the emergency disclosure provisions that would allow you to make disclosures for an emergency. And E911 is based on a consent theory that when you dial 911, you're consenting for disclosure. So I don't think making a distinction on that basis would cause a real-time prospective distinction.
Mhm.
We need an emergency exception. We need E911 capability, but I don't think that should drive the framework of ECPA. So the second distinction is reasonably precise versus general location data. And this is a distinction I think DOJ does draw to some extent now, because my understanding is, and obviously I'm not there, that their guidance is if they're going to try to track GPS data, they suggest that districts use a Rule 41 warrant, although there's some notable cases where that isn't being followed. But their theory, I believe, is that it's constitutionally based, that a GPS can give you information about being inside a structure, and cell site data isn't as precise. I think that's a very dangerous distinction. We've been hearing that today, that this technology is evolving to be more precise, that the GPS technology is being used for different applications, and that providers may track more precise data. So I'm not sure that's the way to do
Do you
ECPA
think,
reform.
well, we had that with the Supreme Court in the 20s and 30s, actually, and I think it was Justice Holmes who said the distinction of whether the bug is on the outside of the wall or the inside of the wall didn't make a heck of a lot of difference. And that, in fact, he speculated, I think in 1928, he said someday it may be possible from across the street or a mile away to tell what's being said inside a room, and we should protect that privacy. So do you think the distinction might be better whether you're inside a room or a place where we will at least impute to you a reasonable expectation of privacy, that what you're saying, or where in your house you are is more private information, has a greater expectation of privacy than whether you're in your house or in the car or at the university?
Well, I mean, to some extent, the Fourth Amendment does turn on that, which is one of the reasons I think Congress really needs to act here, because those aren't the distinctions that are meaningful to us in society. I mean, if I am continuously tracked everywhere I go all day, the fact that sometimes I'm outside and sometimes I'm inside doesn't give me comfort that it was okay to track me during those moments I was outside. So, you know, to me, when we're thinking about ECPA reform, when we're thinking about where we want to raise the standard, it's not, were you in the house at that moment? It is, are we learning something about your continuous movement versus learning something about you at a given moment in time, like you bought a book at Barnes & Noble this morning?
And which should have greater privacy consideration? Your continuous movement or an information moment in time, and why?
I think continuous movement, because it's more invasive and it's more intrusive to be tracked at every moment of the day, all day, than, as Mr. Littlehale pointed out, they get a credit card receipt, they know you were at a gas station. This has been the way it's been for a long time. That's an existing record. Nothing's being turned on. The private providers aren't being enlisted to become government agents.
So in other words, you make a phone call or receive a phone call, and you, at that point, have less expectation of privacy than just the fact that it's in your pocket as you move around.
That's one way to look at it, yes.
Okay. And you said the third basis.
Well, I think I covered the static location versus continuous flow was the third basis I was thinking of.
I'm sorry?
I said the static location versus continuous tracking is the third basis, and one that I would ask the committee think about.
Okay, I have one more question for Judge Smith. And you explain in your testimony that with regard to those magistrate and district courts that are granting access to prospective cell site data under 18 U.S.C. 2703D, specific and articulable fact standard, they are only doing so for limited cell site information. Can you explain the distinction between limited cell site information and full range or unlimited location data in greater detail?
As I understand it, the difference between limited cell site information and what I call full cell site information is the difference between a single tower signaling reflecting the beginning and end of a call, as opposed to all the signaling information that may be derived from signals bouncing off of multiple towers in a given location. In that circumstance, that allows for the triangulation, more detailed, precise location pinpointing of the individual. And to date, as you correctly point out, I am not aware of any published decision by any of the magistrate judges, although we do disagree on the approach to the statute. I'm not aware of any published decision in which a magistrate judge has allowed unlimited cell site information, GPS triangulation, on anything less than probable cause. But now that doesn't mean, and I have been advised in some applications, that just because there aren't any published decisions doesn't mean we're not getting it. So I'm not exactly sure where all my colleagues stand on this, because not everyone has taken the time to publish a written decision.
Thank you. I'll now recognize the gentleman from Georgia.
Thank you, Mr. Chairman. Want the witnesses to respond to this scenario. Bill is a law enforcement officer. Jane is his wife. Bill suspects that Jane is having an affair. Bill issues a subpoena, or not issues, but he tenders a subpoena to a cell phone provider or a global positioning system provider, and request information on the location right now of Jane. Can that law enforcement officer be successful at acquiring that data the you know, where she is in real time right now, and what's the difference between him requesting that information versus the historical data? Where has she been over the last 2 weeks or so? What can that happen? First of all, can you get that information, a law enforcement officer, without showing any kind of probable cause or reasonable suspicion, but just simply a subpoena, ongoing investigation? If I could get a response to that, Mr. Amorosa, Mr. Littlehale, Mr. Zwillinger, and Judge Smith, and I assume that we certainly have, we've already heard from Professor Blaze about the fact that we compile that data. So if you would respond.
Well, let me go first. We don't track individuals unless the trigger goes into effect, which is the 911 call. So we are not tracking, I forget her name, Mrs. Law Enforcement, Jean. We are not tracking her at this point in time. We don't maintain databases on calls that come into the system. If there is a call that comes into the system, there's a non-911 call, we're not creating a location for it, so we wouldn't have it. We don't respond unless there's a lawful request.
And what is a lawful request?
Well, what we're responding to is court orders.
A court order?
And the subpoena of the data.
Blank subpoena or a subpoena issued by the court?
Well, I'm not sure that this law enforcement officer has the authority to issue a subpoena.
Okay. All right. Mr. Littlehale.
From my standpoint, there are two issues. Obviously, what this individual has done, certainly a violation of that agency's policies, very likely a crime as well. I'm not sure that the level of process required, if you assume a jealous officer who's willing to forswear his badge in order to track his wife, is going to make a difference, because he could just as easily swear out a false search warrant as he could, well, I say just as easily. Certainly it would take him slightly more time to fake a search warrant and go to a judge and get it signed, but he could just as easily do that as he could if he had the power to issue an administrative subpoena. So the question is, what safeguards does that particular department have in place? I can't speak for every department. I can say for my department, that would be difficult to do.
Well, can it be done? Theoretically, it can be done, can't it?
Theoretically, it could, yes.
Yeah, okay. And you could get access to the cell phone record real time where the person is located right now based on a subpoena.
If that officer had a pretty good degree of sophistication in their use of electronic surveillance techniques and was willing to fake whatever process they needed to do, and they were able to sneak around in their agency and use the right fax machines and that sort of thing, conceivably, yes. I'd say it would be very difficult to do in my agency.
Okay.
So I'll address a little. When you first started the question, I thought it was going to be a civil subpoena, and the answer was going to be easy because you can't get any prospective relief with the civil subpoena. But clearly it's not. This is a law enforcement process. I don't think subpoena would get this piece of data. A subpoena might get a call record, but if this is historical, it should be produced with a 2703D order, which is the specific and articulable fact standard order. And if this is future, then that's the question we've been debating today. The government would try to get it with a hybrid pen register and 2703D order, and the esteemed judge to my left would decline it, and then they'd have to come back with a warrant. But that's the open question. They'd probably find a magistrate who would allow it. But it shouldn't be a subpoena for prospective, real-time cell location data, even under the current analysis of ECPA. It should be at a minimum a D order for historical data.
I agree with Mr. Zwilliger. I would hope that that Bill, in your hypothetical, would not be able to get the information simply through a subpoena. It's possible that he may. I think it would probably depend on whether or not the provider would feel like that's a sufficiently legitimate order. Most providers, at least as far as I know, have counsel that advise them on what they need to see, and typically a simple subpoena as opposed to a court order directing the provision of this information under 2703D or Rule 41 would be required. So,
yeah, even under FISA, we had some situations where law enforcement officers were able to obtain data promising that a subpoena will be submitted later.
Right. This goes back, excuse me, but this goes back a little bit to my point about no appellate oversight. Even if a judge issues this type of order without any sort of process or without any sort of probable cause or the lesser standard of specific and articulable facts, he or she may be able to do it without any repercussions because there's no appeal, basically.
Yeah, according to the Department of Justice, its policy is that federal agents should seek a warrant based on probable cause before retrieving real-time GPS tracking information. However, Freedom of Information Act requests by the ACLU have uncovered at least two jurisdictions, Florida and New Jersey, that seek this information under a lesser standard. Does DOJ policy bind federal agents or U.S. attorneys? And is it possible that this policy is being ignored in other jurisdictions, Judge Smith?
Well, I don't know exactly what DOJ's policy is. I will say that recently, when the majority of GPS precise tracking information requests that I've seen, they have gone under the Rule 41 standard. However, that has not been uniform. I have seen exceptions to that.
Can I comment briefly on that? As someone who represents providers, I frequently get requests from and subpoenas and other legal process from U.S. Attorney's offices around the country, and I am the one typically telling them that you know that what you've done is in violation of DOJ policy. And sometimes I hear back, oh, do you mean those folks in Washington? To which I say, yes, and you should call them. And they say, well, our boss is a U.S. attorney and has been confirmed by the Senate, and we will do things the way we do things. So to rely on DOJ policy to prevent prosecutors from doing things that we would think that the law would prevent them from doing is somewhat dangerous, and it puts a lot of burden on ISPs and providers to make sure the government isn't doing what it shouldn't be doing.
Thank you. The gentleman's time has expired. The gentlelady from California is recognized.
Yes, I'd like to ask Mr. Zwillinger or Judge Smith. Newsweek reported that location tracking has caused serious harm, and they cited a case where an agitated Alabama sheriff called the phone company's employees demanding that they release real-time data on his daughter's whereabouts. He claimed that she had been kidnapped and that the cell phone company pinged her cell phone every few minutes to identify her location. But in reality, there was no kidnapping. The daughter had been out on the town all night, and the father wanted to know where she was. There was also a more sinister request that came from some Michigan police officers who purportedly were concerned about a possible riot, and then pressed another telecom company for information on all the cell phones that were congregating in an area where a labor union protest was expected. So what ability do you have to challenge the use of prospective cell phone information, as in the case of the Alabama sheriff's daughter? What rights do you have to challenge a warrant for a regular tracking device if you deem it illegal or improper?
If you're charged with a crime and they attempt to introduce evidence obtained in that manner, a motion to suppress can be filed, and if the evidence was obtained in violation of the Constitution, in violation of the Fourth Amendment, there is a suppression remedy. The difficulty is that not everyone charged with a crime is being subject to these orders. If you happen to call or are being called, have been called by a target phone then you may be swept up in a criminal investigation, even though you're a pizza delivery guy or someone who has no contact or no contact with a criminal conspiracy. And so, as I said, that's the problem. Law-abiding citizens' privacy rights might be impacted. They will not know about it because of the gag orders imposed on the providers and because of the sealing orders that the courts impose governing or prohibiting this information from being released to the public.
To add to that, the examples you've given are examples where the police officer or law enforcement officer claimed an emergency. And with regard to the disclosure of historical records, the discretion to disclose information based on emergency is with the provider. So providers that I represent might have forms that the agents have to fill out to certify it's an emergency or to explain what the emergency is and why they should exercise this discretion. For forward-looking data like a pen register or a wiretap, there is no discretion with the provider. If the right official comes and says this is emergency, the provider must provide the data for 48 hours until an order is given and then must shut it off. So there's not very much you can do in the situation where the right official claims an emergency and asks for forward-looking process, except to not provide location data in response to a pen. But again, you're talking about an abuse of the emergency provisions, and there's very little that can be done.
So you're saying that with both the sheriff and with these Michigan police officers, they have to comply?
They have to comply with a pen register request for forward-looking data for 48 hours. I have to admit, I'm not sure exactly what the request was made in the Michigan situation.
Well, it was for a labor union protest that was to be expected, so it was forward-looking.
Yeah. If the emergency provisions were properly invoked, then they would have to comply.
Okay. I would like to follow up on the DOJ policy. According to the Department of Justice, of course, it says that federal agents have to seek a warrant based on probable cause before retrieving real-time GPS tracking information. However, freedom of information requests by the ACLU have uncovered at least 2 jurisdictions, Florida and New Jersey, that seek this information under lesser standards. This clearly seems to indicate a depth of confusion about how to handle real-time data for cell phones, and why is there such a difference between the official policy and what's going on in the ground, and does the DOJ policy bind federal agents or U.S. attorneys to get warrants in any way?
Chu, I'm not an expert on DOJ policy. I would presume that would provide substantial guidance to the U.S. attorney's offices. But again, a lot of the requests are initiated by various law enforcement agencies, the DEA, the FBI. We get requests from Postal Service, postal inspectors occasionally for this type of information. So all I can tell you is it does not seem to me that the policy has been uniformly applied. Whether that's some kind of breach or not, I will not say. And by the way, I do want to say that although we have discussed here some examples of apparently abusive conduct on behalf of law enforcement, in my experience, the people that I deal with, the agents that come before me and the AUSA attorneys that appear before me are dedicated, ethical professionals. I think they are just as troubled by the confusion in this area as the judiciary is.
I would just supplement that by saying that the fact that it is DOJ policy, there's not a statutory provision to point to say that this is required. This is what we're discussing today about to what extent ECPA should cover this. So the guidance is coming from an anticipation of what the constitutional ramifications will be for not getting the warrant. And it seems that some people are making different decisions about that.
Thank you. I yield back.
Thank the gentlelady, and that will conclude our questioning this morning, just in time for a vote. Gentleman from Georgia.
Thank you. I do want to explain the fact that I have abundant respect and admiration for the law enforcement community. And however, for the purposes of creating a picture of what can happen with someone, with a law enforcement officer in bad faith seeking this information, helps us to understand the dilemma of good law enforcement officers seeking the same information. So we don't want the worst case scenario to be prevalent and possible as we move forward into the future. And so I only raise that example of police misconduct to help enlighten us as to what the stakes are for failing to act with this very important issue. And I want to thank the chairman for holding this hearing, and I look forward to working with you, Mr. Chairman, as we peer into the future of technology and what we can do to ensure that the basic Fourth Amendment right to privacy, which is implied in that amendment, that it be upheld. Thank you.
Thank you, and that's the bells ringing for votes on the House floor. Without objection, all members will have 5 legislative days to submit to the chair additional written questions for the witnesses, which we will forward, and ask the witnesses to respond as promptly as they can so that their answers may be made part of the record. Without objection, all members will have 5 legislative days to submit any additional materials for inclusion in the record. With that, I want to thank our panel of expert witnesses for their service. I want to thank the members, and this hearing is adjourned.